One of the biggest mistakes that I see asylum seekers make isn't waiting too long to file. It's actually filing too soon. Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. Now, let me just be very clear about something here. I'm not saying you shouldn't file for asylum. If you qualify for asylum under U.S. law, you absolutely should file. My message is much simpler. It's don't file before you're ready. I've represented hundreds, probably thousands of asylum seekers over the course of my career. And if there's one mistake that I see over and over again, it's people rushing to file asylum applications before they fully understand their own legal claim. And honestly, I understand why. And I think more Americans need to understand why. They need to understand these institutional failures and these institutional weaknesses. Most Americans have no idea that when an asylum seeker first arrives in the United States, they generally cannot work for the first 6 months that they are here. In fact, in most cases, the employment authorization clock doesn't even begin until a complete asylum application has been filed. So that 6 months doesn't even start when somebody arrives in the United States. It starts after they file their paperwork. Now, let's think about what that means. If you fled persecution, if you have very little money, if you need to pay your rent, if you need to buy food, if you have children to support, every day you wait to file delays your ability to legally work in the United States. It's completely understandable why people feel tremendous pressure to get their asylum claim filed as quickly as possible. But with those pressures on asylum seekers, our system creates two incentives that work directly against each other. While one part of the system is pressuring applicants to file immediately so they can start the employment authorization process, the other part of the system expects that the very first application that they file for asylum in the United States is legally sufficient, internally consistent, and accurate enough to withstand scrutiny, sometimes years later. Those two incentives don't fit together very well. So, what should you do if you are an asylum seeker or you're trying to help someone who is? The first step should be sitting down for a thorough debriefing with somebody who knows what they're doing. You need to work with someone who understands asylum law and spends the time necessary to reconstruct your experiences carefully, accurately, and completely. Now, please notice what I did not say. I am not saying that anyone should exaggerate. I'm certainly not saying that anyone should leave out important facts or that anyone should lie. Quite the opposite. Misrepresenting yourself in an immigration proceeding can permanently destroy your immigration future. You need to tell the truth, the whole truth. But you need to do so in a way that accurately captures the facts that are legally relevant to American asylum law. That is an important distinction. A good asylum attorney does not help you invent your story. A good asylum attorney helps you understand which parts of your story really matter from a legal standpoint. So, what are the consequences of filing too early? There's really four major dangers. First is that your application may just be incomplete. If your application is materially incomplete, the immigration court may reject it, require you to correct it, or in some circumstances determine that you've abandoned or waived your asylum claim. In some situations, an immigration judge may even pretermit, that is, deny consideration of, your application without even giving you a trial on the merits. Second, you may fail to plead a legally cognizable asylum claim. And this is one of the biggest mistakes I see. Just because something terrible happened to you doesn't automatically mean you qualify for asylum under U.S. law. The law requires much more than just proving that you suffered. You have to establish persecution, or a well-founded fear of persecution, because of race, religion, nationality, political opinion, or membership in a particular social group. That's a legal analysis. I've seen people tell completely truthful stories that never explain why the persecution occurred or how it fits into the asylum statute. And the really sad part is that the facts may actually be there. They were just never identified and explained properly. This happens all the time. Imagine you filed your asylum application 3 years ago. You're finally in immigration court. You testified truthfully that you were arrested and beaten by the police in your home country. Then the government attorney gets up and asks, why doesn't it say that in your asylum application? Or, if this really happened, why didn't you mention it when you filed your first asylum application? I've seen completely credible people lose asylum cases because of those kinds of questions. It's not because they lied, it's because they didn't tell the truth when the truth mattered the most. They didn't understand years earlier what facts were legally significant. And those inconsistencies don't just come from applicants. Sometimes they come from interpreters. Even if you have an outstanding attorney, that attorney can only work with the information that is accurately communicated. If an interpreter inaccurately or imprecisely translate your story when the application is prepared, that inaccurate translation becomes part of your permanent record. Years later, another interpreter may translate your testimony differently, but actually more accurately. Now the government argues that your testimony is inconsistent with your application. And it has nothing to do with you lying. It's because the written record wasn't prepared carefully enough the first time around. And finally, there's the danger of a frivolous application determination. Keep in mind, losing an asylum case does not automatically mean that your application was frivolous. Those are two very different legal conclusions. But under U.S. asylum law, if someone knowingly files an application containing fabricated material facts, fabricated evidence, or a claim that they know has no legal basis, those consequences can be devastating. A frivolous application finding can permanently bar someone from receiving most immigration benefits under the Immigration and Nationality Act. That is one of the harshest penalties in all of immigration law, and I have seen it happen. All of this is why careful preparation matters. Now, Charles International Law would love your business, but it doesn't have to be us. Just make sure you're working with somebody reputable, someone who knows what they're doing, and someone who puts in the time to make sure they get your case right. At Charles International Law, one of the very first things we do is conduct a comprehensive debriefing before we prepare the asylum application. Our team includes former intelligence professionals with backgrounds conducting structured debriefings and investigative interviews for the U.S. government. Our people are not going to put words in your mouth. We are going to make sure that your true story is complete, accurately translated, chronologically organized, legally sufficient, and supported by the strongest evidence available. We understand the need for you to get to work and to feed your family, but the best asylum applications aren't the fastest ones. They're the ones that are prepared correctly. So, if you're considering applying for asylum, here's my advice. Meet the deadline, of course. You only have 1 year to get your asylum application in once you enter the United States. But don't let the understandable pressure to start your work permit clock convince you to file an asylum application before you're actually ready. Your first asylum application often becomes the foundation of everything that follows. Take the time to get it right. It may be the single most important investment you'll ever make in your future in the United States.